Hi everyone, this is the Christmas special, and this will be the last one that wraps up the year. We're going to be doing 2 success stories as well as 2 news segments. I wasn't planning on doing 2 news segments. I was just planning on doing one, talking about all the changes with USCIS because there's so much already. But then last night, the bombshell report about Operation Irish Goodbye came out, and that just was very disheartening. And so we need to talk about it. But like what we do always, feel free to ask your questions on TikTok, on YouTube, on Instagram. Galen here will be able to gather them. And then once we have enough questions, I stop. I'll answer any of your immigration questions. If I can't, I'll let you know I can't. You know, we don't practice all areas of immigration law. We're primarily focusing on family and business. But if there's anything that I know that you can ask, I'm happy to share it. As well as a lot of people leave questions on YouTube and Instagram and on TikTok. We gathered those questions as well. We can't, reply to every single person, but at least during these sessions, I can do my best to try to answer everything. But the core content of these live streaming is when I film about, live filming about the news that's going on with USCIS, as well as the success story that I want to share with everyone, right? And since I'm filming it already, I might as well make it live so everybody can chime in and watch while I'm filming the success story. And all of these will be posted on YouTube afterwards. You can replay and watch the whole thing. With that being said, hi. Hope you guys are doing well. Let's get to Operation Irish Goodbye first. If you don't know what it is, it's ICE and CBP working together at the southern border, arresting and detaining people as they're trying to leave the United States. You might be saying, there's no way they're doing that. If you search it up, it's happening, and it's going to happen more and more. Now, the reason why I had to stop and really think, do I want to talk about this? Because I know so much of what we've seen this year, so much of it is theatrics. It's scare tactics. It's as intended, and because of their policy, they rightly could use that tactic. They announce this, make it super scary, and it works, right? They all have to do is just announce things, and they shape reality to whatever they want it to be, right? And so in this case, they're scaring people from leaving, from coming back in, more so from coming back in. But the whole idea is that now ICE and CBP agents could be stationed at the southern border, whether at the official port of entry or at the, at the wall or other areas that are preventing people from leaving the US and checking if you have documentation. This is a build on top of the prior memo that released a couple months ago, where they're gonna take fingerprint and pictures of everybody leaving the US. So if you've gone through the Mexico border before, I go almost on a monthly or bi-weekly basis. A lot of times when you leave the US, you just leave the US. You just directly see CBP officers from Mexico, and they don't take fingerprints or pictures. A lot of times you show them and then you leave, right? We're gonna talk a little bit more about that in a bit. But the idea is, well, now we wanna track every single person leaving the country, because if, hey, there's a fingerprint of you leaving the US, hey, there's a picture of you leaving the US, but we don't have a document of showing you entered the US and you don't have a visa or green card or you're a citizen, then it must mean you're illegally here, and that bars you from applying for status in the future, right? Many people who are undocumented here, if they go back and forth, they have multiple entries, that also bars them from filing other legal pathways to citizens. So the US immigration law is set up so that if you entered illegally, then you just stay here illegally. You shouldn't be leaving. Work as an undocumented person in the US until we deport you, or you get a waiver and you get a green card. But we don't want you crossing back and forth. That's the way the immigration law is set up right now. Right now, it's about to get Christmas. A lot of times, people are leaving the United States during this time who are undocumented, and then they might come back in as an undocumented individual, and they enter without inspection. Prior administrations have all tried to stop the incoming undocumented individuals. But now, Operation Irish Goodbye is stopping people who are undocumented from leaving, because if they do that, and if that is so scary that you cannot leave, maybe many people won't come in. Now, what are the consequences if you get caught? Well, you get put in deportation proceedings. So it is as bad as it gets from everything that you see, right? You get put in detention. You might not get bond. You might be stuck there for months and months. It's scary. It's cold. You don't have your medication. It's arguably inhumane in so many different ways. It's underfunded. And so this policy going into effect is causing a lot of scare in the community. I go to Mexico, again, on a bi-weekly or on a monthly basis. For the past several years, I always get asked, I'm going to self-deport. Is it okay if I self-deport? Is it okay if I just leave the country and then use the CBP app and just say, I'm out of the country now, I'm never going to come back? You know, because of all the craziness, okay, I realize America is definitely not welcoming me, I'm just going to leave forever. Is it okay if I leave? Do I have to go to ICE and say, I'm self-deporting, register me, and then I'm leaving? My advice has been, it's okay, just leave. No one is going to stop you. You're not going to be detained. Once you leave, then you self-report. That's the safest. If you directly show up in front of an ICE field office right now and say you're going to self-deport, they book you in. Now you might be part of a process. It's much easier and cleaner if you just self-deport. But now that is no longer the case with this Irish operation. I hope people who are self-deporting, who are leaving, make a conscious decision, think through everything that happened this year. They can no longer live in the US. They do not like it here. They want to go back to their families, so they're self-deporting and they're not coming back. I don't want this last leg of the trip, this last mile, where they stuck up in detention accidentally. And that would be just so tragic. So all the changes that are happening with USCIS, and these things are coming out on a weekly basis. So I want to report two big changes. One is what's going on at the citizenship interviews. I've never seen this before, but clients, when they go to the N400 interview, citizenship interview, they first, when they give their appointment notice, say, hey, I have an appointment, let's say at 7 a.m. or 8 a.m., they immediately take your picture and do your biometrics. You are saying that this is you. Boom, captures your identity. Then you sit down, you wait an hour. They call you up. You go into the room. You sit down, you do the entire interview, you pass with flying colors, congratulations. You get up, you leave. Before you leave, boom, capture your identification again. Another picture now, another biometrics. We've been told it's because USCIS is trying to catch fraud. Apparently, there are a lot of people who are going to these interviews. They say, hi, it's me, but it's not them. And then they are doing this test for somebody else. They're passing the English test, they're passing the English test, they're passing the civics test, they're passing the questions, and nobody is the wiser because there's nothing that's taken. There's no voice recording, or people can always change their voices, people can always change their looks, but here with the biometrics and the facial recognition, stops it at the appointment, and right after the interview you come out, they take it again. Never seen that in the history of civic interviews, but we're seeing it now. We're also seeing a lot of different adjudication processes from Santa Ana office to LA office to Sacramento. A lot of these officers are adjudicating these citizenship interviews all differently. Some are still approving it on the same day, which we've been told that they're going to completely stop, but they still are doing it. And so the consensus amongst a lot of citizenship immigration attorneys is that there's so many things that's being changed all at once that there's no uniform policy yet. So a lot of officers who've been there for a long time, they still have the discretion to adjudicate according to how they used to adjudicate until and there's a final rule. But there's small little things like the whole biometrics, like the where it's not done by that officer, it's done by the group, right? Those are being created and those are being enforced. There's a lot of other random things, right? Like at the citizenship interview, are you able to bring an interpreter? Will they use your interpreter? What can their interpreter do? What certification do they need to have? New policies came out. They talked about it. Are they enforcing it? No, like not all of them. The new requirements that weren't even announced, like for example, bring your children and your beneficiary to the interview and making that a requirement, but it wasn't written, it wasn't requested, and so you blindside the applicants showing up. I was like, oh, you didn't bring your kids. I put them in daycare. I didn't know I was going to bring them. So there's all sorts of confusion around adjustment of status, around N400, and the consensus really is USCIS right now, it's like an earthquake happened and your house shook and everything is on the ground. Everybody's trying to cleaning up, trying to move one file over here to another here. We're cleaning one room at a time. There's just a lot of different things. So just kind of go and help the officer do their job, be polite, do your best to prepare well, and don't be surprised if something is new that you weren't expecting. That's for the practitioners as well as for the clients. That's one USCIS update that just happened this week that I just want to announce, right? The second major update that we're seeing is that a lot of change of status applications are getting requests for evidence, are getting biometrics, are getting a lot of discretionary requests for evidence and whether to deny the case or not. Again, in the past, when you file for a change of status, it is not a discretionary adjudication, meaning the officer cannot say, I don't like you and deny your case. If you meet the requirements, you should get the benefit. Now it is not. Secondly, in the I-129 business adjustment change of status application, criminal records, arrest records are usually not a concern. Usually it's at the consulate stage. Usually it's at the adjustment of status stage. Now they're bringing it down to even a change of status at the business case. Today's success story is going to be one of those, but I just want to share that news where when you file a change of status, you're going to get a request for evidence to do a biometrics, and you're going to pull up your prior arrest records, and you're going to have to explain. And even if you do explain, they have the discretion to deny your case. And if they do, your visa is canceled, you have to leave the country, and you have to reapply overseas. USCIS is getting stricter with change of status, change of employers, change of anything. And when you're applying for citizenship, they're cracking down as well, making sure you are who you say you are and adjudicating you. This might be good news to the public because it's like, great, USCIS is becoming stricter, more difficult to commit fraud. It's not a good news for the average applicant who's just confused enough about this whole immigration process, and now when what they say and what they do is different, it makes it even more confusing. At least I'm happy that fraudsters and people who commit crime and try to smuggle people in have it much more difficult, but you can best that they're trying to figure everything out, and USCIS, in order to keep them on their toes, they're going to keep on creating these policies and changes, so it makes it even more difficult for them. So that just makes our job a lot more difficult. They have to keep up with USCIS news. That makes it difficult for the public to kind of keep on learning what's going on. And so hopefully I continue to do these live sessions so I can share everything that I'm learning so everybody can learn it all at once. And that's the news for today that I was planning on talking about. Like USCIS changes at the interviews, USCIS changes at the change of status. And then I'm going to be doing 2 success stories. One is a change of status, change of employer from a TN status to a TN status for a Mexican national. And the second one is about the EB-1A for an Indian national that's never been to the US that got approved. So those are 2 success stories. I'll take some more questions, and then I'll do the TN one first, and then I'll do the EB-1A after.
Is it true USCIS is going to take back citizenship? And if so, how are they going to do that? And then can someone challenge this after they do so?
We're going to talk about that for sure. So it's not so much USCIS taking back citizenship. It's the Department of Justice denaturalizing people who already got their citizenship. USCIS is going to be working very closely with the Department of Justice to denaturalize, because who has all the citizenship paperwork? It's USCIS. So USCIS is undergoing a major overhaul to find all the faulty USCIS applications. So the process looks like this. The Department of Justice looks at a lot of these quote unquote worst of the worst criminals who are citizens but weren't born here, so they must have naturalized. They look at all of these individuals and say, hey, USCIS, cross-reference these 100,000, 500,000 individuals that we want to denaturalize. Then USCIS pulls all of those records and double checks it and sees, okay, this was their application. Can we find any sort of fraud in it? Oh, we did find 1, 2, or 3. Now we have grounds to denaturalize because they falsified their citizenship application. So even if they have been a citizen for 5, 10, 15, 20 years, we can now denaturalize them. And so they give that information to the Department of Justice. Department of Justice sends a service and the official trial starts. It is not with USCIS. It's completely with the Department of Justice. That is how it's supposed to be done. The fear is USCIS takes that one step further and says, oh, you gave us 100,000 people that you want us to denaturalize. Here is 500,000 people that we reviewed and we want to denaturalize, and we see all these different issues. Please now go and investigate. And then it's up to the Department of Justice to decide, okay, well, we want to just focus on the 100,000 or the 500,000? I'm making these numbers up, by the way. I'm just saying that's just as a reference. This has been underway since the Obama administration in reviewing the denaturalization process. Every year, there's only a handful, between 12 to like 100 people getting denaturalized, but that number will ramp up. It's been in the works. They've been planning it. They want to do it, but how far will they take it? Will it, and can you challenge back and can you argue? That's gonna play out in the courts for sure, and we'll see how it happens. But for anybody who is a citizen, who have applied and is concerned that their citizenship had some sort of error on it, and whether or not you should FOIA to get to see your record, that's totally fine. You could totally do that. That's safe. We're recommending people to do that. Do a Freedom of Information Act, pull your citizenship record, double check. Oh, I did fill out that incorrectly. And whether or not you want to file an amendment to clarify, hey, by the way, this is it. 99% of people don't need to do it. 99% of people don't need to file an amendment with USCIS to say, hey, I want to clarify my info 100, especially if you've been a citizen for years. I wouldn't worry if it's a typo. I wouldn't worry if it's an honest mistake. It's much more severe if it's a pattern of offense, right? And so that is a thing that that you should be concerned about, right? And so, but again, I think 99% of the people who've been naturalized in the past 10, 20 years should be fine. We'll see how it plays out.
Are they still detaining people at USCIS AOS interviews? How often is that happening?
We are not seeing it widespread, as in we're not seeing every single person that's going to these interviews getting detained. We're not seeing it across the country. We're just seeing a few instances here and there. And that's why it might be posturing, it might be image projection, it might be trying to create this fear, but it did happen. It started a couple weeks ago in San Diego. We're seeing it more. Let me see, my phone is not here, but we did see another attorney in my thread that had their spouse also detained at a different port, not in San Diego. So we are seeing it, but with the number of adjustment of status interviews going around the country, if it was completely widespread, it would be completely chaotic. And we'll see a lot more of that. So we're definitely not seeing it everywhere.
Does the travel ban affect pending asylum-based green cards?
Meaning you are in the U.S., you are filing for asylum and for a benefit. The travel ban, does that affect you? Does it stop your benefit request? I believe it does. And there's the 19 countries, and then there's the 5 additional ones. It for sure applies to the 19. I haven't read in depth about the 5 additional ones.
So for this naturalization or denaturalization, isn't there like a statute of limitations on that?
The tricky thing about it is they say you defrauded the U.S. government. And so because that application was void from the moment you started it, we can go all the way back and trace it all the way back. So that's why we see, some cases like 20 years, they could still go back and say, hey, we're going to denaturalize you.
Can you expedite a marriage-based green card case?
Legally, technically, totally possible. In the past couple decades, definitely see it. Rare and far between. Lots and insurmountable effort in order to get it done. As you can imagine, there might be hundreds of thousands of people in front of you in line. Why do you get a cut in line, right? So the super rare cases is when you take it and you do it in court, right? And you're like, what? Do it in court? That is a thing. You take your application, you go to an immigration judge, you do it in immigration court. You do it at the consulate. They can approve I-130, 45 and adjustment, which is crazy. Getting senators and congressmen involved to expedite it. But again, it's like 0.001%. It's probably not worth it unless you have a crazy important reason. Like with the Afghanistan situation during the Biden era, they expedited all the I-130s, right? Because they wanted to adjudicate everything much faster. Right when Russia invaded, not Russia, right when Israel was attacked, they immediately expedited a lot of the E2 applications and a lot of other things as well, right? So depending on global politics and how things are moving, USCIS listens to the White House to expedite certain type of cases.
Does everyone in deportation proceedings get deported if they show up to their court date?
No, right? Because you could show up and well, first of all, we see a lot of immigration judges recalendar. So you're supposed to show up, but then boom, they recalendar it. You show up and you can push your calendar hearing, your master calendar hearing, to a different date. Not all deportation hearings are the same. There's master hearing, there's merits hearing, there's also appeal. So it depends on if it's an expedited removal. So just because you have an immigration court case doesn't mean if you show up immediately, you get deported.
Can a lawsuit force USCIS to make a decision, even if there's an FBI background check?
That's a great question. From my memory, looking into this, you're talking about the mandamus action. USCIS is taking far too long in adjudicating your case. That is a violation of your rights. So you sue them and you force a judge to make USCIS, the government agencies, to adjudicate yes or no, yay or nay on your application. And typically it works, but USCIS has said, well, it's not up to us. We're giving it to the FBI, and the FBI has to adjudicate it now and investigate. And if they can't make a decision, then we can't make a decision. Essentially, they're passing the buck, they're passing the responsibility. And so in a situation that's like that, right? If the court is forcing USCIS to adjudicate a case, and if USCIS is saying, well, I have to defer to the FBI, and they haven't made a choice, then you are stuck with a decision. Well, do you now sue the FBI and make them do the adjudication, or is your lawsuit against USCIS mandamus sufficient? From the best of my knowledge and how I remember everything, in the N400 citizenship context, when they're doing background investigation, at first, USCIS's deference to FBI was not granted. So USCIS cannot use the excuse, oh, FBI is investigating, and therefore I have to, therefore I can indefinitely spend 1, 2, 3 years adjudicating a case that should take 8 minutes. So that excuse didn't work. But recently, that excuse suddenly became more okay from something that I read. So it becomes much trickier. So I don't want to say directly USCIS cannot use that excuse. So that's number one. Number two, if you use the USCIS to sue them on, if you do a mandamus action against USCIS on a 751 waiver or other types of applications where they require FBI investigation, those actions, USCIS has much more sway to where they can say, I'm relying on the FBI to make an investigation before I can adjudicate. And the reason for that is citizenship applications, it has much stronger of a weight to it, right? You're going to be a citizen. If USCIS doesn't approve your case or indefinitely adjudicate it, they are limiting your right to vote. So the consequence is extremely severe. So that's why the courts do not want to defer to USCIS. Just kick the ball down the road and say, oh, somebody else, is still doing their part, and therefore they don't have all the facts to make a determination, right? The courts did not find that very convincing. But other things where you're just trying to get a visa or trying to get a green card, the courts greatly defer to USCIS. I don't know if that's your question, but hopefully I answered it.
I have DACA. Can I do advanced parole even if I have a removal order since 2002?
Probably not. But if you really look into it, maybe you can. I would not feel safe for you to leave the country and come back with an active with a deportation order. CBP is totally going to stop you, put you through the ICE proceeding. It's going to be scary. I would feel much better for you. You can apply for reentry permit. You can apply for advanced parole. I mean, you can get it, but before you leave the country, definitely close your prior deportation order. It's no longer active. There's a phone number you can call to make sure it's no longer active. There's a website you can put in your case number to make sure it's no longer active, because that's what CBP will reference. If CBP sees, okay, there was a deportation order, but everything's been closed. You got DACA, you have advance parole, you did go to do what you say you were going to do, and you're going to come back and live your life. Okay, great. Then they'll let you in.
Should I be concerned about being detained during a 751 and naturalization interview? I mentioned in my AOS application that I overstayed my visa. Would they use that as a reason to detain me?
Because you are in your 751 and N400 stage, meaning you already have a 2-year conditional green card, meaning the prior officer who adjudicated your 45 adjustment of status application already excused your overstay. You are not at risk of getting directly detained by ICE at that interview, at your 751 and 400 interview, one or the other or both, right? Due to the unlawful presence, right? That is not the reason that they will detain you. They could, however, detain you if the officer finds that your 751 application is wanting, it's weak, it's fraudulent, and they are planning to deny your 751 and therefore deny your N400, and therefore you are now deportable. So if you have a weak 751 case, if your marriage is falling apart, you don't have a lot of joint documents, your spouse is not going to show up with you, if you have a background that looks fraudulent, meaning, the two of you together, statistically, it's super rare, nearly impossible, that is something to be concerned about. But if you have a very strong 751 case and your only worry is that unlawful presence, visa overstay, I would not worry about it. I would power through to do the 751 and 400.
Are immigrants still getting due process after being detained?
Due process means different thing to different people, and there's different levels of due process. So this is now we're talking about political theory now. How much due process does one get? An immigrant doesn't have the same amount of due process as a citizen. An illegal immigrant definitely doesn't have have the same due process as an immigrant. And somebody who's in deportation and expedited removal proceedings definitely doesn't have the same due process as, let's say, somebody who is on DACA. So your question, are we still having the same amount of due process? In this year, this administration has changed that due process standard in the immigration context, and basically everybody got a little bit less. If you have a green card, you're practically treated like somebody who just only has a visa. If you have a visa, you're almost looked at very suspiciously as if you are an illegal alien. If you're an illegal alien, you're treated like you're a criminal. If you're a criminal, they're hunting you as if you're a terrorist.
I had my AOS interview on July 28th. I have not received approval or any notification from USCIS. How much time do I wait until I contact them for an update?
You could just use Emma, you could use an 800 number. Just do it now. Learn the tricks, learn the codes to type in, because that's a good skill to have, especially you might be doing this for a year or more. So just go ahead and do it. And they say you need to wait longer. Well, at least you tried, and then they'll see that you tried, and then you wait the period that they recommend you to wait, and then just call again.
We're waiting for an N400 decision after passing the interview in 2023.
That is extremely long. 2023, nearly 80% of cases get approved day of. So if you're still waiting for a decision after 2023, you could almost consider doing a mandamus action to sue them. So definitely check Emma, check with 800 number, check the field office, do an info pass, do everything you can to push it forward. If they are not responding, if they say they're still doing an investigation, that's when you do a mandamus action.
I'm in deportation proceedings, and I got a letter from USCIS letting me know DHS is looking to move forward.
With what?
Probably the deportation.
Maybe. Or maybe Department of Homeland Security is planning on moving forward to close the case. Maybe, right? So definitely take a look really closely at what they're trying to move forward on, what you filed, what your request says. Sometimes we're extremely happy when we see there's a case that finally Department of Homeland Security is trying to move forward, right? So because we have so many clients that we want to reopen the case so that they could do adjustment of status. But the Department of Homeland Security says, nope, we're not going to spend our time doing that. The case is closed. You're stuck in limbo. So we're trying to get the Department of Homeland Security to move forward. Maybe you're trying to apply for a bond and they don't respond to you, say, no, we're not going to do a bond. But if they're going to move forward to recommend the bond, that would be good.
How long is a 601 waiver taking?
Approximately 3 years.
I did my biometrics already. How long would you normally wait for the Social Security and work permit?
That's all. It's hard. Let's just say 3 months after your biometrics, 3 months to 6 months.
Does an I-829 denial terminate lawful permanent resident status? And can long-term issuance of I-551 stamp establish lawful permanent resident for purposes of removal relief? 5+ LPR, 7+ in the U.S.
I love it. You are such a sophisticated individual. I asked that question so many times. I spent hours researching this. The answer that I found is unfortunately no. I know it's disheartening. I did not want to come to that conclusion. But from all my legal research, once an 829 has been denied, on paper, the courts will say that stopped your lawful permanent resident status, even though you continue to have 551 stamp, which is just USCIS granting you the image of being a lawful permanent resident and having all the rights and privileges of a permanent resident, but your 829 is the official decision. So you cannot use your 551 stamp time to qualify for cancellation or removal and immigration court to get your green card back. Now, nothing is for certain. I researched this, I analyzed this. So where I'm at right now with this issue is, I would say 80-90% chance, especially in the 9th district, which is in California. The circuit courts will say, if your 829 is denied, you cannot count that time for your cancellation or removal to qualify for it. So we will deny you're still deportable. But there's still that maybe 10%, 20% chance that maybe the courts won't rule that way. I just haven't had any clients that were in this situation that wanted to try. But at least from my honest reading of everything that's related to this issue, that is the conclusion.
So I had TPS and it's terminated. This is the same person who has a pending 45 I-13765 no receipt notice.
Oh, I see. Well, if you have a pending 45, I think you're fine. There have been a lot of people who are on DACA who are on DACA or who are unlawfully present, and some of them have gotten real IDs and they have been able to fly. So we are hearing that there's TSA agents, there are CBP agents at domestic airports that are looking for people who have looking for their identification, looking for their legal status. And I think there was a guy in Chicago who didn't have their green card and was challenged, and he didn't present it and got fined. So if you're in a situation where you have a pending 45, carry your pending 45 paperwork and with your real ID, and you should totally be fine.
I never received my USCIS letters from my ex 8 years ago, and now I'm in deportation proceedings.
You can do a FOIA, which could take a long time, but that's assuming you have good paperwork with USCIS that they can give you. If US doesn't give it to you, you run out of time. If you cannot continue your deportation proceedings and push it down the line, then it'll be difficult to make an argument. If you know the attorney that worked on the case, they might be able to give it to you. They may not. Also, past 7 years, they might have shredded everything already as well. So it's definitely a very tricky situation. But I would say consult with a deportation immigration attorney, not us, because we don't do the deportation work. I would recommend you contact the immigration that does that and see what possible documents you could have received from your ex and from USCIS, and see what you can argue with the immigration judge.
I am from one of the travel restricted countries. I had a pending 485. Has USCIS stopped processing it?
Yes. Stopped all benefit requests.
I'm waiting for my priority date to be current. Is it normal for USCIS to ask to retake biometric appointment after 2 years?
Yes, especially now they just released a new memo, I believe. I haven't read it in depth myself, but I believe it says biometrics are only valid for 2 years or 3 years. So they're going to stop they're going to discontinue reusing biometrics, which has been a great policy for the past like 6-7 years, but they're going to stop that now.
Can my citizen's son file for his mother, although she is a VAWA case pending?
Mother is VAWA case pending. Can her son, who is a U.S. citizen, petition for her? Absolutely. One single individual can have multiple petitions where they're the beneficiary. I-130, spouse, children, parents, sibling, right? You can have multiple employers be petitioning you. So you could be the beneficiary and the recipient of all these different immigration petitions.
How can I adjust my status through EMI-2 while pending asylum without leaving the U.S.?
You have to close the asylum case, you have to close the asylum case and have either the immigration judge, approve your I-140. Hopefully your I-140 is already approved, right? So if your I-140 is approved, you close your asylum case and you file adjustment, and hopefully the judge does it. If the judge is not willing to do it, then the judge has to transfer your case to USCIS.
What do you think about the pause for the 19 countries?
I think the Trump administration 2.0 is much more sophisticated than Trump 1.0, all right? With the first time in office, he tried it, boom, bunch of litigations, shut down, couldn't do it. Trump 2.0, much more sophisticated. What I think is going to happen, my predictions, 19 plus 5, eventually it's going to continue to expand. I think it's going to stay. I think it's going to get even more intense, and it will last throughout this administration. That is my prediction. I don't think this travel ban is something that's going to go away very fast. Reason being, he wanted to do it the first term, couldn't do it. Now he's doing it now. He's potentially going to use it as a negotiation piece with the other countries. But my prediction is the travel ban is going to stay for the duration of his term, and it will expand.
As a Haitian immigrant, can I travel with my 2-year green card?
I don't know enough. I don't know enough. I want to look more into the 19-country ban. I want to know what the CBP's view on Haitian immigrants are who have green cards. You're not applying for a benefit because you already have it. So chances are you should totally be fine, because as a green card holder, you are a lawful permanent resident. You can exit and leave. It's a 2-year green card, so they might inspect you and pull you into secondary and question you about your marriage and the validity. But I would definitely be more cautious. So I would definitely want to think about it a little bit more. But generally speaking, if you have a green card, you should be able to leave.
If I'm from the EU, what's the best visa to get so that I can eventually become a U.S. citizen?
So that's a misnomer that a lot of people have, and people think about chain migration or pathway to citizen. In our U.S. immigration law, it's not a stepping stone. You don't necessarily get this and you can get this and you can get this. Everything is kind of in parallel. So there's non-immigrant visas where you can come into the U.S. to live and work, but that doesn't lead to any green card. If you want a green card, you still have to do something else in parallel or simultaneously. But as an EU national, you probably could do the E2, which is very convenient and much easier than many other visa applications. And then once you do the E2 application, if let's say you get married, then you get your green card, and then you get a citizenship. So a lot of people do that path, right? That's a formula: E2, marriage, green card, citizenship. But there's obviously maybe 100 other combinations.
If my country is on the restricted list, would a mandamus application work? I applied for 45 4 years ago.
No. If your country is on the travel ban list where you're stopping all benefits, mandamus will not expedite the process.
Is it true that USCIS is now conducting VAWA interviews due to the VAWA fraud and scams?
Yes, they have been doing it. They have doubled down on it, and there's official policies that make it even much more important. So this is definitely real and true.
Is the O1 still the best alternative to the H1B to avoid the 100,000 feet?
No. H1B alternatives. O1 is definitely one of them. O1 is definitely one of them. If you're from a country that qualifies for TN or E2, those are all really good alternatives as well. F1 to come to the US and then H1B is one of the primary alternatives to the H1B, or directly skipping all that and just directly do EB1A or directly do EB1A or K1. Those are all good options as well. O1 is definitely not the immediately go to the H1B.
Are people renewing green cards and getting arrested at biometrics at USCIS with a misdemeanor?
I have not seen that, so I don't think it's happening. I watch immigration news pretty carefully. What I do know is that at these biometrics interviews for I-90 or for various things, the people who do get detained, many of them might be the ones who are doing the self-deportation process, or people who are have major criminal records and they're filing for DACA renewals, etc. But not necessarily the I-90 misdemeanor. Having just one misdemeanor doesn't make you deportable. And when you do an I-90, it's not a USCIS officer reviewing it in depth. And so biometrics is almost automatically generated. So if you have a green card renewal and you have a misdemeanor, the chance of you being detained at a biometrics is next to none. I would feel very confident going.
Follow up to the I-829. Have courts granted relief to EB5 investors based on good faith investment? And in light of current California timelines, is a BIA appeal advisable or look for alternative relief?
Great question. I do not have enough expertise and knowledge on the EB5 front to answer that. Definitely a very capable EB5 firm should be able to, but we don't do enough of it to answer.
How long does it take for a spousal visa from Mexico or fiancé visa, which is easier and less costly? And can you help with the process?
Yes, we can help with the K1. We can also help with the I-130. And I think the best thing to do is set up a 250 consultation. You should probably book with the Spanish department if it's from Mexico. And our team, both Gabby and Margaret, can really help you out and analyze everything. We've done plenty of them.
So basically, what work visas are there beside the H-1B that allow you to get to the U.S. and get a job?
There are many. So let me ChatGPT it for you. E2, H-1B1, E1, E2, E3, L1A, L1B, F1 CPT, F1 OPT, M1-ish, not really, you can't really work. You could do J1s. So I don't know how many, I ran on my fingers, right? But there's definitely a lot of different options. I didn't even say O1, O1A, O1B, right? So there's a lot of different categories that you can potentially qualify for. TN, yeah.
Is it safe for reentry by advanced parole to home country for non-main applicant pending asylum?
I don't recommend it. I know people have succeeded. I even know main applicants have succeeded. I highly don't recommend it. It is a very difficult time. It's a very challenging time. The scrutiny is extremely high. And so if CBPC sees any sort of connection that they suspect, the first thing they'll do is confiscate and detain. And so I don't recommend people doing that.
When they look through our phone at the border, what are they looking for? Is there anything legally they could use?
They could use everything and anything against you. The only thing that they cannot use without their legal counsel's approval is any confidential information you have shared with an attorney. The first success story we want to focus on is a Mexican national changing employers on a TN visa. We all know TN has gotten extremely strict this year because of the new memo. They're hyper focusing on your degree and your job duty. If your TN visa is based on an engineering degree, you really need to prove that this company, this job position requires an engineering degree. So we have a client, a packaging goods employer that reached out to us. They say, we just finished the interview process. We really like this individual. We want to hire them as soon as possible. What's the timeline? What's the fees? And how fast can we get them here? Because they have an important project in January that they had to file. Here was the problem. It's a packaging goods company, right? Think UPS, think FedEx. They're shipping boxes. It's holiday season. They have to ship a lot of things. The individual is a Mexican national with a bachelor's degree in engineering and already on a TN visa in the US. It is far too dangerous to leave the US to apply for a TN visa and to and to go back through the border. And so they wanted to do a change of status within the United States. But we knew that it is extra difficult nowadays to do this because they really want to hyper focus on your bachelor degree and with their job description to see if it matches, because they only want these key individual roles. They don't want Mexican nationals, Canadian nationals to be coming in to stealing US employer jobs. We lack engineers. We want real engineers, not just fake engineers with an engineering title. So on top of the normal TN application, we doubled down on the work products. What is this engineer doing? What kind of design is this engineer doing in order to create the boxes, in order to ship? And that requires an engineering degree. So we did all that extremely fast, within a week, filed it. Here's the crazy part. On the I-129 application, when you do a change of status in the United States, now it becomes discretionary because, not because, new memos have come out by USCIS saying change of status, discretionary. If you're a tourist visa changing status to a different status, it's discretionary. If you're doing an extension of status, it's discretionary. Meaning if they don't like you, they could deny you, right? It is not just purely based on you meet the requirements. We have to give it to you. Now, USCIS officers have a lot more discretion. And in this case specifically, even though he wasn't changing a status, he was just changing employers, USCIS still issued a request for evidence saying, we see a previous arrest record. Please go do a biometrics. Give us all the details of this arrest record. Even if you're not convicted, we still have the authority and discretionary authority to deny you. Please show us your positive and negative factors. So we went in depth to explain the situation around this particular arrest. It looked bad. And the reason it looked bad is because on the arrest record and on the charging documents, it's evading the police. And that just conjures up images of, high-speed chases and running. You're just, why would you evade the cops if you're innocent, and all sorts of things. We digged in deep, and the story was they were in a car, parked. The lights were on. The cops came by. The cops was suspicious what's going on, came back, knocked on the window, pulled it down, wanted everybody's driver's license, wanted everything. Our client was sitting in the front seat. His house was right there. And he said, you know what? This is not my car. I'm not driving. It's my friend's. I'm just going to head home. Not to me. I don't, open the door. Open the door. Police freaked out, thought they were going to book it. So tackled the client to the ground, arrested them, booked him, and now he's evading police because he opened the door. Is it a miscommunication? Is it a cultural thing? You can just imagine the miscommunication and how it happened. We explained it. Our client is not a bad person. He's an engineer. The company really needs him. He will solve a particular project that will save millions of dollars, that will be able to infuse into the US with taxpayer money. We did an in-depth response within another few days, responded to the request for evidence. The case got approved, and now he can officially work at the new company. TN visas used to be 2-page employment letter, couple documents with a resume. You leave the country, couple hours, you come back in, and you get a new visa and you work for an employer. That used to be how the game was played for decades. Now, TN regulation has gotten stricter. People are not planning on leaving the country because they are afraid they can't get back. Everything will be abandoned, so they're doing change of status. But when you do change of status, USCIS has their discretion, and so now you need to do a TN case as if it's a H-1B case, as if it's an E-2 case, as if it's one of those big company documents, because USCIS is just used to adjudicating cases like that. So our advice to anybody who's doing TN cases, don't treat it like the TN case that you're used to filing in the past. Compare more to the more complicated H-1B, E-2 type cases that you would do here. Go in depth, gather a lot of documents. And I know the employers are like, I just want to hire this employee now. Set the expectation correctly, prepare, file, and we got the case approved. So that's the TN case. Credit to Grace and Grace's team. They pulled it off. They talked with the CEO. They talked with the applicant. They talked with so many different people to get everything ready. It was a very scary situation, but at least the case is approved. So we're thrilled to have them back in the country. This is an Indian national that's applying for an EB-1A application who's never been in the United States, which makes it quite hard, but not impossible. This Indian national, his specialty was he was in finance, but doing zero emission real estate buildings. Okay, it's like three things combined. He's doing finance for real estate that's trying to reduce CO2 emissions. He's an Indian national that is based in the UK. That's the situation. But the reality of filing this case, the story is so much more than that. And I want to walk you through the entire process so you can see the ups and downs and the changes and the decisions and the strategies that led to the approval that just happened like last week. This time last year, I jumped on a call, did a consultation with a client. It was a father who really wanted to do the EB-1A so that the daughter can get a green card in the United States. So many fathers want to apply for green cards for their children. In talking about it, it was quite difficult. One, because the children is already really old. So even if you get the EB-1A approved, the priority date is quite long. But if he doesn't do it, then it will never happen. So wants to do it as fast as possible. This was like December. They wanted to file in like a few weeks. I said, I have to check with my team. It's nearly impossible. Was it a strong case? Not that strong. The client wanted to file for 5 different categories out of the 10. They want to prove a lot of things. We only have a few weeks. How can we argue so many things all at once? Think you have to write 5 essays instead of 3 essays, right? So I have to check with my team. And when we actually did look at all the different things that they submitted and they want us to argue, it wasn't that strong. So it was a relatively medium case. It wasn't a super slam dunk case. We were preparing for a request for evidence. And we also had to strategize, well, the daughter might age out, so we don't want to do premium processing, right? Normally, 99% of our clients, we push them to do premium processing because you file, you get an answer, you respond, you win. But if you slow it down, well, what if it takes a year? And in this case, it did take a year. We filed the case in January. There was no response up till November. But we started to see USCIS coming out with these policies saying that they're going to make EB-1A a lot harder. It's going to be 5 categories instead of 3. We're seeing all these trends of cases getting denied. The client and us, we decided, you know what? It might be better to do the premium processing now, maybe get a request for evidence, but at least we could respond to it now, right? So we waited an entire year. We already gained that year in priority time to freeze the age of the child after the case gets approved. So, all right, a year might be enough. Let's do premium processing. Fingers crossed, we started to prepare the request for evidence even before it came. And then the case got approved. So we looked back on the case. It's like, okay, this was an impossible case that we filed within just like a 2-week time period between the middle of December to the middle of January. You cut out the 2-week vacations. It's really 2 weeks to gather everything, to write everything, to submit. It was crazy hard. And when I looked at it just now, reading through everything, it was quite hard. Let me go through the details with you. The client is in the field of doing finance, real estate, and reducing emissions. So it's a green push. It's in the United Kingdom, but he's an Indian national. We argued high salary. The salary was not high, especially in the United Kingdom standards. The only way we were able to argue it's high is we categorized them very, very narrowly. Compared to other people doing finance, real estate, and in carbon emission, compared to other people, his salary is low. But compared to government workers, his salary is high. So he's a government worker in the United Kingdom. Therefore, we compare him only to government workers. And we don't compare him to government workers in London, where, the salary needs to be a lot higher. We compare him to the region that he was in the United Kingdom. So we narrowed it down and we made that argument. The other thing we did to bolster that argument is also to show the history of his work. From the moment he graduated to now, he's always been paid a lot over the years. He has over 20 years of work history, and he's very sophisticated and very, very capable. And that's why he's chosen to do this. And that argument was actually one of the strongest arguments. The other one, the lead contribution that he has made, well, he made a lot of contributions to the United Kingdom, but he was only there for a few years. Did he make a lot of contributions in India? It's arguable. And there were so many things that he did, but did it all revolve around the same thing? Not really. So original contribution and leading critical role, because he worked in the Majesty's Kingdom and he was a pretty high up on a project management basis. So we argued, well, he was leading critical role on all of these projects. Does that sound like a slam dunk EB1 genius case? It's hard to argue. But we made that argument. He wanted to argue membership. We completely had to drop it because we just didn't have time. We were waiting for maybe we get a request for evidence and then we respond to it. So high salary, original contribution, leading critical role. And the last one was like judgeship. He was managing the funds for Her Majesty's, His Majesty's Treasury to fund all these green projects. So he had to judge different things. That's part of the job. USCIS always denies cases if you are judging something, if it's part of your job. You can't say you are a judge and you deserve to be EB1A if your job is to judge. But we did our best to try to argue, well, it's not exactly part of the job. This is his job description, but not judging these particular projects. He was so extraordinary at his job that His Majesty assigned him to judge all these other projects to advance the kingdom's work. That almost sounds religious. But we prepared that in 2 weeks, and what made this case even more difficult was that his intent to come to the US, what is he gonna do? He has no friends, family, contacts, business relationships, investments. He doesn't even have a whiff of an idea of how he's gonna make it the United States better. And given this administration that don't care about the environment, it is not a priority, even harder to argue, right? Does the US need another finance guy doing real estate on environmental things? That is not a priority to the US, even harder. So in this case, if people were placing bets, would not have been approved. In an administration that is getting stricter and stricter, even harder. We were preparing for a request for evidence. Why did the case get approved? It's only a Christmas story. I really don't know. I cannot tell you. It is not anything that we did, but I could tell you the story of it, right? And so the client contacted us in December. We understood everything. We wanted to file in 2 weeks. That's the deadline we gave ourselves. Because if we waited longer, if we filed in April, March, June, made the case stronger. But if you win the battle, you lose the war. If his whole intent is to bring his whole family, bring his daughter to the United States, and then make the US better, if he cannot do that, then he wouldn't do anything, right? So we drew a hard deadline in January, filed it, got the case approved. And then the second part of the miracle happened was that we just saw the visa bulletin for Indian nationals, and it just shot up by a year. So the chance of his daughter getting the green card is actually just that much higher now. It will be so crazy if this case gets approved. I'll be so happy. And I just want to share this story with everybody who's going through this process, right? Because EB1A, it's an endless hole. You can spend 10 more years on your case and it can still be better because it's about, are you the best? And that question, there's no answer to that. And so you can only try your best, prepare everything, give yourself a deadline and file. Obviously, the client is very grateful, wrote a very, very nice email to us, and the team is celebrating, and I'm very happy to share this story with you. Cases are still getting approved, even though when everything seems to be marked against it. But if you don't try, you just don't know. That's the second story for today. Thank you. If you have any questions, feel free to reach out. Take care. Bye-bye.